We're all set. 1 o'clock. We will get going. Welcome everyone to Legal and Financial Basics. This is a community dementia education program of Alzheimer's San Diego. Very pleased today to be co-presented with our guest presenter, Yvonne Amrine from Amrine Law. Longtime friend, supporter, and sort of expert volunteer with us here at Alzheimer's San Diego. I'm going to allow her to introduce herself to you and tell you more about herself and her estate planning and elder law practice when we get going here. Just going to get us through a couple of kind of housekeeping slides before I turn things over. My name is Amy Abrams. I'm the Director of Education at Alzheimer's San Diego. Very pleased to be here today, assisted by my colleague, Rebecca, who is a member of our clinical services team. Rebecca, yeah, say hello.
Hi, good to see everybody.
So Rebecca and I will both be kind of back behind the scenes here today, responding to some of your questions in writing, responding to issues, questions in the chat if you have them, generally just sort of being a support and kind of compiling questions for our couple of question and answer breaks that we will be having during the program here today.
Wonderful. Well, thank you so much, Amy, for having me here. It was just a year ago that I was doing this live in your office. It's hard to believe it's been that long. But I'm always happy to provide some background and education around the ideas of financial and legal planning for a person with memory issues. And to tell you a little bit about myself, the reason that I decided to go into elder law is because of my own personal experience. Back in 2001, my mother lost her second husband, my stepfather, and I started to notice issues with her memory. It took a couple of years for us to get a diagnosis of Alzheimer's. And actually at that time, it was mild cognitive impairment. They didn't want to say any scary words and call it. And actually, I think even back then, it was really hard to tell what type of dementia it was. But in 2003, she did get a formal diagnosis. She was able to live on her own until sometime mid-2006. Of course, we had family members that lived close by, and she was safe and secure and doing pretty well on her own. By the time we got to 2006, luckily, my stepfather, I should say, passed in 2001, if I didn't mention that. So she was really alone for that period of time. But by the time we got to 2006, she was going to need more help. And luckily, my stepfather had also put a very good plan in place. So I know what that good planning looks like and what it can do for your life and how important it is to being able to age and have a more graceful experience going through this than if you were in a crisis mode. So I'll probably be bringing in a little bit of experience around that as well. So my mother was able to live in her home using the long-term care policy until 2013. We started to look around for care in 2012, and she was in a board and care situation in Arizona up until 2016. So if you do the math on that, we paid for care for 10 years. That's a very long time to try to budget for something as large as in-home care, 24-hour care, and then residential care after that. So it became very important to have the advanced care documents in place and have the key legal documents in place as soon as we knew there was a diagnosis. Luckily, that had been done just a few years before my stepfather had passed, and so we were in a good position. So we're going to talk about the advanced care planning basics first. Then we'll go on to the other topics that Amy had mentioned, and see if I can get this slide to you can control Amy's screen. I'm going to try. There we go. There. All right. So advanced care planning, what does that really mean? It means that you want to make sure that someone else can make a decision for you if you can no longer speak for yourself. It ensures that your future decisions are based on your personal values and your preferences. But to do that, it actually requires that you talk about it, right? It requires that you share what your preferences are. And it also has a legal and financial component to it, right? So you're going to not only need to talk to that person that you trust, that you want to be named to be able to make these decisions for you, but you're also going to want to talk to an attorney in a lot of cases and your financial advisor so that you can make sure that what you want to happen is going to happen. In my mother's case, we had a long-term care policy. We were able to keep her at home. That's what she wanted. And I remember her saying, okay, the day that I don't know how to find the bathroom in my own home, I'm okay. You can move me at that point because, you know, resources are finite. So we want to make sure that we take that into consideration. But again, it all comes down to communication. So that is really the basis of getting started with your advanced care planning is communicating, thinking about what you want and communicating those wishes and talking to your team. See if I can make this work again. Seems to have a little bit of a hesitation. There. All right. And the quote, advanced care planning is about planning for the what ifs that may occur across your lifespan. So I always tell my clients when you do an estate plan, it's not something that you just throw in the drawer and say, oh gosh, I'm really glad that process is over and I never have to look at it again. You do because things change, right? Our kids grow up, they leave the house. Maybe the people that we had named to be their guardians or maybe named to be the trustee over that trust are now older themselves, or maybe they've passed away. So I always say it's the 4 Ds. It's if someone that you've named in your plan has died, that might be a reason for having it looked at. If you've gone through a divorce or you've gotten married, that's another reason. A decline in health, that's usually a very good reason to pull that plan out and look at it again. And then also just a decade, because laws change and rules change, you should also have your plan dusted off, looked at every 10 years, just to make sure that it's up to date with the current law. And I am really struggling with this, Amy. Thank you. So the value of planning ahead. Do we make good decisions when we're in a crisis? Generally, I don't. I don't know about you, but we want to reduce the need to make decisions during a crisis. If we can get a lot of this planned out ahead, you're giving a roadmap to your loved ones to be able to carry out your wishes. So that's a good place to start. That value of planning ahead is also making sure that the decisions reflect your personal values and preferences, like we said before, and that there is an eligibility for public benefits. You might not ever think that you're going to need to be on Medi-Cal or that you would need Social Security, SSDI, or even SSI. Those are two different programs. One is if you've worked, one is if you haven't had enough work paid into the system. So those are things that you may need to plan for, and you want to make sure that you have a plan that's flexible and that's going to allow you to do that. And then the other reason that we want to plan ahead is we want to avoid a formal probate situation. It's never fun to be in crisis and then need to go to the court and have the court make personal life-changing decisions for you. So I don't know how many people have ever had to go to court for any purpose, whether it's family law or probate or anything else, but it's not a very comfortable situation and it can be quite costly. So you really do save money if you plan ahead and make sure that you don't leave these things left undone. And I'll talk about a little bit more of the concepts there when we come to it. All right, some key legal concepts. Key legal concepts that we first want to talk about, and what I deal with every day, is estate planning. So just because you would avoid probate and you avoid court, you don't avoid doing all of those same steps of things that a probate court would have you do to get title changed on property. So, and now we're just talking about what happens when you die, right? We're not really necessarily talking about what happens if you're alive and well, but that's the estate planning side of things. So the administration, protection, and distribution of assets in a manner that is consistent with what you want. And I will tell you that if you haven't written a will or you don't have a trust, don't worry. The state of California has written your will for you. It may not reflect your wishes. It may require that you go through probate and that your estate is exposed to all of those costs of probate, but it is there. It is a lengthy process, and it's gotten even more lengthy since we're in COVID because the courts have been shut down for so long. There's a huge backlog, and it's taken them a while to get up and running in the new COVID era. So it's not something you really want to do through the courts, but all of those things do have to happen. And next slide, I'm just going to go ahead and let you do it since they're not working for me. Benefits planning. So the difference between working with an elder law attorney and working with someone who doesn't deal with elder law is that I really take into consideration the possibility of needing that government benefit. So I still use the same toolbox that an estate planning attorney would use, but I do it in a different way. I put more tools in there for your successor trustee so that they can look at the way things are laying out in the moment and say, gosh, we're running out of money here. I don't want to have to sell mom's home. Do we need to qualify for a government benefit? It's a really good idea to have a plan that it has that flexibility and make sure that you don't deplete the assets before is absolutely necessary. Next slide. Also part of that is special needs planning. So that is protective planning for individuals, not only with developmental disabilities, as the slide says, but it can also be used if you're 65 years, or actually I think 55 years or older, if you haven't had a lot, you don't have a lot of assets, but you know that you have a diagnosis that's going to cause you to run out of money. Here in the state of California, we can use what's called a pooled special needs trust to be able to make sure that those funds last for your lifetime, or at a minimum are used for things other than what government benefits could pay for. So you're not spending down to be able to qualify for that government benefit. You're actually preserving it all within the rules of the state of California to be able to do that. So that's special needs planning. It can also be very handy if you have an adult child who is not productive, is not working, maybe qualifies for that government benefit, so that when you pass, that they can get those benefits, or maybe they're already on benefits and you don't want them to be disqualified from those benefits after you die. All right, next slide. So one of the key concepts that we'll be talking about today is capacity. And that really deals with your ability to make legal decisions. And it's not a fixed thing. It's a moving target, really. And if you are living with someone with dementia, or if you have dementia, as you know, you have moments of clarity quite frequently. And in fact, my mother used to always say, you know, there's something wrong with my memory these days, but she didn't really have that knowledge that, yeah, it was really going to progress. She would even forget, right? So that sort of goes along with the idea. But at some point in the process, after you get your diagnosis, the first thing that I always say you should do is get in front of an attorney and have all of your finances and your legal documents looked at, because you want to be able to get yourself a robust plan in place that's going to allow you to be able to have that roadmap out in front of your loved one for the time when you can't speak for yourself. And so that you kind of have an idea about when it's going to be time to move. You've had those conversations. Again, we're talking about communication here. You're communicating with your financial advisor, your attorney, and that person that you're naming as your successor, either agent or trustee in the plan. And capacity is a big part of that. And the next key concept that we like to talk about is conservatorship. So where we talked about probate happening after a person dies and being that part of that administration of the trust or will that happens after you die, probate can be involved even when you have a good plan in place also, if siblings or some of your loved ones don't agree about what's going on. But conservatorship happens when you don't have proper documents in place. You haven't created a financial power of attorney. You haven't created a healthcare power of attorney, or for some reason they're inadequate for what you need to do. Then you're going to need to go to court and get what is called a conservatorship. And this is a legal decision made by the probate court that takes your rights as an adult and gives them to another person. That person is going to be your conservator, and you are going to be the conservatee, or the person that's been conserved. In other states, they call it guardianship. And here in this state, we call guardianship that for a child, someone under the age of 18. But that family member, or it can be a professional, is going to make these decisions for you. And I can tell you, when I first went to law school, I volunteered at the conservatorship clinic. And even after I got my bar card, I ran the clinic for a little bit here when we were over at Madge Bradley. Now we're over on Union Street. But the Legal Aid Society helps with that. And there's a lot of expense and a lot of difficulty when you have to go through that process. So there are just a couple of key legal documents we'll talk about here in a moment. And those documents are going to keep you from going through a conservatorship. All right, so now let's get to the key legal documents. So these basic documents are going to be found, some or all of them, in a good estate plan. If you have real estate, if you own real estate, or you and a bank, more likely, own real estate here in California, you want to have a revocable living trust. The reason you want to do that is because the one asset you own that cannot transfer by any other means is real property over a value of, I think this year it's a little over $160,000. So all of you out there, you can raise your hand if you own a home or you have a mortgage on a home and the value of that home is over $160,000, right? Probably everybody. So if you have that, you want to make sure that you have it titled in the name of your revocable living trust. That is something I can't impress upon you enough, because the process for probate is so long. There are other means of transferring property. We won't get into a lot of detail about that today, but for the real estate, you need a trust. Also, a will. Everybody's probably heard of a will. In the state of California, you can write one yourself. You can say who you want to get your stuff. When you do that, you're handwriting it on a piece of paper, you're dating it, and you're signing it. And that just says who gets what. It still has to go through probate. It does not avoid the probate process, but at least you've been able to say who you wanted to get what, and you don't have to rely on that will I talked about that the state of California has written for you, which is called intestate, meaning going through probate without a will. The will that we're talking about here that's in parentheses is called a pour over will. So if you have a trust, you will also want to have a pour over will. That pour over will does just like a pitcher of water. It takes assets that may not have been titled in the name of the trust, and it pours them into the trust after you die. And that's just a means of avoiding a formal probate. Sometimes we lose track of a bank account here or there, maybe an annuity payment or something like that. And we have to have a means to make sure that everything goes where it's supposed to go. So the powers of attorney, I really like to start with that because the powers of attorney really operate during life. And those are the two documents that are going to help your loved one or your professional that you might hire make everyday decisions for you, whether they be about your health care, about where you live, or paying your bills, or arguing a bill, or representing you in a lawsuit, anything like that. The powers of attorney must be in place. These basic documents we're talking about are just some of the documents a good plan will have. And I will say that as an elder law attorney, I write these documents very differently than an estate planning attorney would do, because I take into consideration government benefits possibility and also special needs trust, and having that language in there that would allow your loved one, if they were disabled, to not be kicked off benefit if you pass, but also if your spouse has a dementia diagnosis or something like that, and the well spouse dies first, we can also use special needs trust in that situation. Next slide. So other important documents are a detailed advanced healthcare directive. Now, this power of attorney for healthcare that was talked about on that past slide, here in California, we really do call that the advanced healthcare directive, and we name that agent right within that document. In some states, you'll hear it termed a living will, right? And this piece that we're talking about that would be considered a living will is really talking about your end of life wishes. What you would want to happen if you were in a coma, what you would want to happen if you had a terminal illness and the doctor needed to make a decision about some type of treatment, and that your directions, and of course there are conversations that go along with this with your loved one or your professional about how you want that to go. Do you want a feeding tube? Do you want extraordinary measures? All of that is contained in that living will. The waiver of health insurance portability and accountability, that's that HIPAA waiver. And all of us have signed a HIPAA acknowledgement when we go to our doctor's office every year for our annual exam, right? So that waiver is allowing someone else to be able to look at your healthcare records. If you have an advanced healthcare directive, the statutory form that comes through the state of California, it does not always include that HIPAA waiver. So you want to make sure that you have a HIPAA in place. The ones that you fill out at your doctor's office are only good for that doctor. If you fill it out at the hospital, even if it's an advanced healthcare directive at that hospital, it's really only good for the care that you're receiving in that hospital. So make sure you have a good standalone document that can be used. Everyone's probably heard of Do Not Resuscitate, DNR. In years past, and I know in other states, my mother was in Arizona, she had a separate DNR that the doctor and I filled out that talked about whether she wanted to be resuscitated or not. And that's those end of life wishes we're talking about. Here in California, we use something called the Physician's Order for Life Sustaining Treatment. And you will still also see DNR when you go to the hospital, because it might be an order that's on your chart while you're in the hospital, but it won't be something that is useful if you're at home. If you're at home, the two documents that you're going to want to have available if you don't want to be taken to the doctor or to the hospital in a life ending situation is, you've got your advanced healthcare directive, your wishes, that's going to be that legal document. But this Physician's Order for Life Sustaining Treatment, the POLST form for short, that is a physician's order that lives in your chart and it travels with you everywhere you go. So usually it will be the Department of Health and Human Services has a little vial of life sleeve with magnets on the back, and you can fold that up and put that right on your refrigerator so that the EMTs know where to look for it. And then you can also keep a copy of that. I know with my mother, my brother who lived near my mother kept a copy of it in his glove box, along with that advanced healthcare directive naming him as the agent. So the physician's order for life-sustaining treatment becomes very critical when you have a chronic or terminal illness. You want to make sure you get that in place. Next slide. So I talked about this at the beginning, what I call the 4 Ds. You want to maintain those documents. You want to review that existing estate plan. If you have one of those Ds happen, a death of someone named, a divorce or marriage, or birth of a child that you want to maybe gift to. And then if there's a decline in health, you want to make sure you take a look at it there, that new diagnosis. And then also, at least every 10 years, you want to have it reviewed. Also, another thing people don't really think about, and this really came into play in 2008 when a lot of the bank consolidation happened in financial industry. You want to make sure that you know who's your designated beneficiary on your financials. And that means your bank account, that could be your retirement accounts, those types of things. You want to make sure that it reflects what you want in your plan. So that's going to be something that you go over with your financial advisor if you have one. If you don't, you're still going to want to make sure you check that on your own. Go to your bank or go to each institution individually. And then also get that in front of your attorney and make sure, I always tell my clients, print that out, the signed version of it that you've submitted, and put a copy of it in with your estate plan. That gives your loved one or your professional a roadmap at the end so that they can find those assets once you've passed. Here's another thing I can't say strongly enough. If you're going to name someone in your plan, please ask their permission first. They may not be in a position to be able to do that, especially with an advanced healthcare directive. They may not want to be the one to do that. And the last thing you want is to have them get that call at 3 o'clock in the morning and be told that they are named to make this decision for them, for you, I should say. So please make sure that you talk to that responsible party and that you make sure that they have a copy of that or that they know where to locate that. Next slide. All right, so we've gone through the basics and the key legal documents, and now we're going to talk a little bit about financing of long-term care. Do we have any questions?
We do.
Yes. We have a question that came in the Q&A. Thank you for those that are using. It says, please explain the changes that will occur from Prop 19 regarding a child inheriting property from a parent.
That is a very deep subject, and I would like to defer that to the end because it could take up quite a bit of time. So Amy, are you okay with that? Or would you? Okay.
Yeah, we'll just leave it unanswered,
promise.
But we'll come back to it.
I promise I'll answer it.
And then we have one more question in the chat. It says, can a property, specifically a land, in another state be written in a pour-over will?
You can always designate what you want to happen to your property, even if you own it in another state. If you are planning to use just a will, and you die here in California, and your property is in, say, Oklahoma, then a probate will need to be opened in California, even though the property, that's the only piece of property you own. But you'll have to open that here, and then you will have to open a second one, what's called an ancillary probate in Oklahoma. And it will be processed there, and then it will be accounted for here in California, and the final order will be made here in California. So if you own real estate anywhere, I highly suggest that you put it in a trust in the state that you live in, and that will avoid that. So it's titled in the name of the trust in Oklahoma, the Oklahoma recorder's office will have a record of that, and your trustee will be able to manage that for you. Any follow-up on that?
We'll let you know if a
Okay.
follow-up question comes in.
Okay, anything else?
Looks like we have a question coming in that I think will be answered a little bit further in the presentation. I think that's it for now. Quick question, is it required that you have separate people be your powers?
No, if you have just one person you trust, then you can just name that one person to be your successor trustee, the executor on your will. They can be your agent under healthcare power of attorney, and they can also be your financial power of attorney or POA agent as well. So it can be one person. Sometimes what you don't want is you don't want to name more than one person to serve at a time. So that I've had situations where I'll tell people I will not write that document for you, because it is the surest way to have an argument in your family. It's not an honor you're bestowing on your family, it's a job. So make sure that the person that you're naming has the time, the wherewithal, the ability, the temperament to do those jobs. And wearing those different hats, sometimes with the advanced healthcare directive, you might actually want somebody different than you have over the financial stuff. Just because of their personality, they might be better suited to have two separate people doing that. That's my advice.
Perfect. Thank you so much.
Mm-hmm.
Great. Yvonne, we're pretty well on track. We're just about 2 minutes off schedule. So we're doing pretty well. And I just want to let folks know that the closed captioning service is available now. If you want to turn that on or off, depending upon your preferences, you now have that option. So,
all right.
Thank you.
All right. So strategies for financing long-term care. You know, that's always the question, right? Let's go ahead and first start talking about what is long-term care. And then from there, we can talk about how to pay for it. So long-term care is not nursing services. It is custodial care. It can be delivered by someone who is not a nurse and not a medical licensed professional, right? So those services are non-medical, and they help you to perform activities of daily living, or ADLs. So that's toileting, grooming, dressing, eating, preparing meals, and there are also incidental ADLs as well. So you can have these services delivered in a number of different ways. It might be an in-home care company that provides that. It might be an adult day program. These days during COVID, we don't have any adult day programs open, so or very limited. I know Glenner Center is still operating in some fashion, and that's really awesome to be able to have that. But the one that's on the bottom there, the PACE program, that is the program for all-inclusive care for the elderly. They have had in the past very robust day programs, and they are at this point only able to offer their services by way of caregivers coming into your home. So they've had to change that model a little bit, but those community-based services are what are used to be able to keep you in your home and allow you to age in place in your home. The PACE program is a needs-based program in a lot of ways. I do know that they have some programs in their adult center that they allow people to come in and do and pay for. But generally, St. Paul's PACE and Gary and Mary West programs, which you'll get a little more information on contact information for them, they are a home and community-based waiver program. There is another program that you may have heard of called IHSS, or In-Home Support Services. And that is where a caregiver is trained to be able to take care of you in your home. And it could be your loved one, and they would get a reimbursement of $10 per hour to take care of those services. Medi-Cal would do the evaluation and figure out how many hours you would be allowed based on what your needs are. Residential care. Residential care can be done and this is where you no longer live at home, you're going to be living in a community based residence. So it's going to be either a board and care. Here in the San Diego area, we have what are considered 6-packs or 6-bed type situations, and you'll find those in your own neighborhood. My mother-in-law just moved into one actually in La Jolla, run by 2 nurses, and it is able to meet her needs. She actually needs full care pretty much. If she weren't there, she would have to be in a skilled nursing setting. Assisted living. Assisted living is where you need to help with those activities of daily living, but they bring it to you there and provide that service right there in the assisted living. Those are usually a little bit bigger. They're usually anywhere from 10, 20, upwards to 100 people in that community. And then there's also memory care, and memory care is very specialized. And sometimes you have to go into memory care if you need that next level of care above what an assisted living could give you, and you need more direct redirection and direction to keep you on schedule and keep you keeping your days and nights straight, and just prompting you to do what's next in your day. Skilled nursing care, and we're now talking about long-term skilled nursing care, you may have seen it as a rehabilitation type center. And so a lot of skilled nursing centers, they don't want you there for the long term. They really just want you for the rehabilitation portion of your care. Then they want you to go home, or they want you to go to an assisted living. But those are all the types of things that are going to encompass long-term care. And now we're going to talk about paying for it. What is the cost of long-term care? Well, of these 3 different types, the community-based care, if you're paying for a caregiver at home, you're paying anywhere from $25 to $35 an hour. You maybe only need them, 3 hours per day, 3 to 5 days a week, something like that. That's fairly manageable. You might be paying, $3,000 to $5,000 a month, something like that. As your care needs grow, you're going to need to increase those hours, and quickly in-home care becomes very, very expensive. And that might be a reason that you need to move more to the residential care setting. Adult day programs can be less expensive if you've got a spouse or loved one that you're living with, and they need to be able to carry on with their day or work. Those adult day programs can be a less expensive way of making sure that your needs are met. The PACE program, again, that's a Medi-Cal funded program, home and community-based care program. That you have to qualify. It's a means tested program, and we'll probably talk about Medi-Cal a little bit more in a few minutes. The cost of residential board and care, those can go anywhere on the low end, in that 6-bed unit from, I don't know if I even see anything under $2,500 anymore, but that would be, maybe out in La Mesa or in East County somewhere. You might find the lower cost, but it can go up to my mother-in-law is paying $8,000 a month in La Jolla. But, for what she needs, that's really the best care for her, because she's got basically a 3-to-1 ratio in that high-end board and care. Whereas if she were in assisted living, it might be a 10-to-1 ratio. And her care needs are so high, she would not fit into that. So the care cost can go anywhere from, I said, what, $2,500 up to $10,000, $15,000, $20,000, depending on the level of assisted living or memory care that you're in. Some of the continuing care communities are even more than that, and there's a buy-in to those. So if you have the means and you want to look at those, you should start looking now, so that you can understand what your choices are and kind of what your budget would be for that residential care, because at some point you may need it. So it's a good idea to plan ahead. Skilled nursing, again, we don't want to live in their day to day. No one wants to live out their days in a hospital bed. And that is the most expensive care delivery. And that these days is starting at about 10 to 12,000 and going up to 18,000 a month. All right, so how do we pay for that? Well, I hate to tell you, but Medicare is not going to pay for this. You probably already know that by now, but some people are surprised that, that Medicare is not going to pay for that type of care. It's going to be your personal savings and your assets. So if you haven't bought a long-term care policy and you're over 60, you're probably not going to want to do that. You can get one all the way up to age 80, but it's going to be a really expensive policy. So you might want to take a look at some of the other financial tools that could be available to you. Charitable gift annuities. If you are thinking that you want to make sure that you can afford your care, but you want the rest of it to go to a nonprofit, you can do a charitable gift annuity, and that charity will take on and take your money and give you a monthly amount that you believe you're never going to need to go higher than, say, $15,000 a month for care. They would be able to stretch that asset out for you and make sure that you can qualify or that you can pay for care. Reverse mortgages, I will just say, are the most expensive money that you will ever borrow. And with our real estate prices here in California, there are much better ways of financing that than going into a reverse mortgage. So if you've planned ahead, hopefully you will never need to look at that reverse mortgage, because when you run out of the cash to pay for care in the reverse mortgage, you're going to have to go find care elsewhere. And when that happens, then you're going to have to sell the home. And generally speaking, you may have very little left to pay for care after that. You can convert life insurance, and a lot of people do that. They convert life insurance to get into care because it's not going to be any good to them when they die. Maybe the reason they bought it was to make sure that their kids or their spouse would be okay after they died. And really, the better use of that money might be just to pay for your care. So that's something to take a look at. Medi-Cal. Medicaid is a federally funded program, and Medi-Cal is California's version of it. Home and community-based services, the PACE program, is under that umbrella. In-home support services is under that umbrella. And here in California, skilled nursing is what we consider, or the state of California considers, long-term care. And that's living out your days in that hospital bed. Getting into that type of care takes a crisis situation. You have to go to the hospital for at least 3 days, and then you have to go to a rehab center that would accept the Medi-Cal dollar afterwards. If you're unsafe to go home, then you can get that type of Medi-Cal. I tell my clients, don't plan for that. Plan some other ways around that. The PACE program is a really good way. Nobody really wants to leave home. So, an elder law attorney can help set you up so that the PACE program could take care of your needs and doesn't totally bankrupt your spouse or your family when you die. So that's something that we use. VA benefits is a very good benefit, but the laws have changed with that. And as of October 18th of 2018, you can't have more than about $130,000 in assets between you and your spouse. And so it makes it very difficult to qualify for that. If you are a veteran and you've served at least one day during a wartime period, then that benefit's available. We'll talk about some more of those benefits here in just a few minutes as well. So one thing to always keep in mind is that what you do pay for medical expenses and custodial care is all tax deductible. Now, with the new rules that have come into effect, they raised it from, if you have medical expenses that are 10% or more of your annual income, then you can deduct those on your taxes. So you can lower your tax, the tax that you owe on your income by deducting that. If you don't have 10% or more, you're not going to be able to deduct those expenses. So that's always something to take a look at. Next slide. This is something that I see once in a while, and it's difficult when you have someone who's still working and they start to have memory issues. So the one thing I will tell you about employment considerations is, if you do realize that you're having trouble remembering things and you know it's affecting your work product, make sure that you talk to an employment law attorney first before you disclose this in the workplace. There are protections, but you do have to make sure that you understand when you are disclosing this, they're going to give you some accommodations, but your employer is going to be looking for a way to get you out of that position. If it starts to really affect your work product, they're going to want to get somebody that can take care of your job, and they won't have to deal with that loss in productivity that might occur because of your memory issues. So it'll be the best $500 or $1,000 you've ever spent to go to a good employment law attorney that represents those that might need to disclose a health condition in the workplace. This is also going to help you when you get ready to apply for any kind of a benefit, short-term disability or long-term disability benefit down the road. So make sure you do that first. There are employee assistance programs, the long-term disability, the Family Medical Leave Act benefit. In fact, I told my husband when he needed to go and start doing these things for mom, that maybe he should take a week off and not take it out of his vacation time, right? But take some of that medical family leave time that we all have coming to us, depending on the size of the employer. Sometimes a larger employer will pay for it, but certainly sometimes you just need that time away to be able to take care of business. And then also take a look at those early retirement options if employment is still something you're doing. Go ahead. One thing to also make sure that you keep in mind is, if you are applying for SSDI or SSI, that you take a look at the Compassionate Allowance provisions, and there's a list of dementia type diagnoses that would allow you to qualify for that compassionate allowance. What they do is they fast track your benefit so that you're not waiting for months to get your SSI or your SSDI benefits going. And I can tell you that SSDI is one of the most difficult benefits to get unless you've got one of these, where they see that and they just fast track it through, and there's not a lot to try to appeal. You don't get as many denials that way. All right, next slide. So now we're going to talk a little bit more in depth about those veteran benefits. If you served in our armed forces, U.S. Armed Forces, you may have health benefits available at the VA centers. If you served at least one day during a wartime period, and it doesn't have to be in the theater of war, you might be able to get some pension benefits or non-service connected custodial healthcare benefits. There's also service connected. And one of the things that I always like to mention is if you have a dementia that was caused by Parkinson's and you served in the Vietnam War, you might actually have a service connected disability income benefit coming to you, and it pays a lot more than the non-service connected benefit. So make sure that you take a look at those. There's also a death pension for the surviving spouse. Once you die, especially if you get this non-service connected in place and you have it for a year or more, then that's also going to help your surviving spouse after you pass. There's lots of good VA caregiver support programs as well. And I know there's also some programs that will give you a short number of hours, like maybe 10 to 12 hours a week. And sometimes that's all you need to be able to stay at home. One thing to keep in mind is if you're trying to qualify for Medi-Cal and you do get the benefit, the non-service connected benefit, that VA payment does not count toward your income. So you should still be able to qualify for your Medi-Cal benefit with your regular Social Security income and maybe what small pension you might have. But that VA pension that you get is not counted in your income. So make sure that you keep that in mind. The caregiver support program has that adult day healthcare. They have home-based primary care program. It's a lot like the PACE program, not quite as robust from what I've been able to see, but it's that skilled home care service. And then also they do take you all the way through hospice care. Medicare. So what does Medicare pay for? They pay for 80% of any hospital care cost or medical care cost. And that Part C, that Medicare approved private health insurance, that is that Advantage Care plan. It might be part of that, but it could also be that supplemental plan that you're paying for. Once you get to the age of 65, you find that, okay, that 80%, I still can't afford the 20% of medical costs that are coming through. That's when you're going to want to have that supplemental piece. If you go on to Medi-Cal, Medi-Cal takes care of everything that would be part of that supplemental care piece. And that includes the prescription drug coverage. You don't have that donut hole you're dealing with as well. And there's also the FG and the Medigap plan. I guess is where that supplemental care goes into. So it's a good plan. And we all, as we get into our 60s, we can't wait to hit to 65 because we feel like we're not going to have to pay for that health insurance anymore. And so, it does pay for a lot, but it does not pay for, as we've said over and over, the long-term care piece. So Medi-Cal, it's a needs-based program, and this is going to cover that home and community-based care. It's going to cover that skilled nursing care. It's going to also be that health insurance piece for you if you are a needs-based, and that is age 55 years or older with a chronic health condition, or if you are disabled, or if you are very low income. So children, anybody who is not working, you're going to be able to get some form of medical help, and that's going to be covered under Medi-Cal. So I think you can read the slide there, the low cost health coverage for children and all of those I've covered. The Medi-Cal for long-term care. The thing that's important to understand is we in California, I'm part of the National Association of Elder Law Attorneys. I am president this year of the Southern California chapter of that. And when we get together and we talk about benefits law, we say we have a magic wand here in California. And that's because our rules are different than the other 49 states. They are under different rules that don't have as many protections as we do. And so spousal protection is something that's been very important, and that protection for the middle class. I will say that when we're talking about middle class, we're talking about, being able to save your home, but not much more than that. The spousal protections, I think we've got some numbers here coming up in the next few slides, but it's really very limited, and it's really just meant for the state not to have to end up paying for all of the Medi-Cal care for the next surviving spouse once they become ill. Next slide. So those who are eligible for SSI and SSDI can also qualify for Medi-Cal. But again, it's mostly for the medically needy, and that's the piece that you have to remember. But that magic wand that I have allows me to keep you from having to spend every last penny in your bank account or your retirement account to be able to get qualified for the long-term care portion of Medi-Cal. Key concepts to understand is the share of cost will be calculated, and estate recovery is less prevalent than it used to be. The only thing I'll say about estate recovery is here's another good reason to have a trust. As of 2017, if your property, your real estate is in a trust and none of your assets go through probate, then there will be no recovery for any long-term care benefits or any Medi-Cal benefits that you ever received during your lifetime. That's pretty important to remember. And again, if you own real estate anywhere, you'll want to make sure, because they can recover it from another state, you'll want to make sure that you hold it in a trust. Next slide. So we'll talk a little bit more about in-home support services. Again, that's the program that's going to allocate the number of hours of care they believe that you need. I can tell you, most people that go into IHSS are not happy with it because they are stingy with the number of hours. And you have to fight, you usually have to hire an attorney to fight that and appeal the number of hours to increase the number of hours. And that can get expensive, especially for someone who's already on that low end and doesn't have a lot of funds to spend on attorneys or fighting something. But it can be very helpful if you do have a family member who is already committed to doing your care and staying home. Then they can get those funds, and they can at least have some remuneration for the care that they're giving you. Community-based services, adult services, the CBAS and the ADHC, those are the PACE program and some of the community-based waivers that do pay for assisted living. So if you, that assisted living waiver helps there, but those community-based services are also the adult day programs that can be paid for. And then it also pays for that skilled nursing level that we talked about that pretty much none of us really want. But if we have to have it, we do have that, that safety net there. Go ahead. So eligibility, how do you qualify? Well, this is a list of what assets are exempt. Your home, your principal residence. If you have a rental property, you're not going to be able to qualify. However, with my magic wand, I can get you qualified by transferring that to an irrevocable trust. And we're going to talk about the Prop 19 implications. People had asked about that. I'll address that in the question section. But you can, as an elder law attorney, I can get things moved out of your name into an asset protection trust so that you can meet these needs before you spend down. Spending down to qualify for Medi-Cal is never a good idea. Always, always get an evaluation from an elder law attorney before you try to do that. Your household goods and personal effects, as long as you don't have, Renoir in your art collection, is going to be considered exempt. One vehicle, a term life insurance policy, you can still continue to pay on that. If it has cash value, then it can't be more than $1,500. Burial plots, I a lot of times often tell my my families to go ahead and do that pre-planning now. It's a good idea to get that taken care of, so that, and use that to spend down. That is a good way to spend down. Your IRAs, your retirement accounts are not considered an asset. The RMD, that required minimum distribution, is calculated into your income on a monthly basis when you go to qualify, but none of those funds ever actually have to go to pay for Medi-Cal. Next slide. Spousal protections. So I said we'd talk a little bit more about that, and here we are. The Community Resource, or CESRA, Community Resource Allowance. This year, the number is $130,380. So when I'm doing planning for a couple, I'm taking all but $132,380, because the person who's qualifying can't have more than $2,000 in their name. And I'm moving everything else to an irrevocable trust or to family members, so that a person can qualify for that benefit. You also can, your community spouse, that's the well spouse, can retain that $130,000 as money to live on, as things to pay for whatever might be needed, maintenance in the home and that type of thing. That number increases each year. And this year it's 130, next year it might be 132,000. There's also another number that you need to pay attention to, and that's the minimum monthly maintenance needs allowance, or MIMNA. That MIMNA number goes up each year. This year it's 3260, and that is the amount of income that your community spouse or your well spouse can keep. So you can have a spouse that is making $200,000 a year, and the ill spouse has maybe only their Social Security, or maybe Social Security and a pension. That $200,000 a year that community spouse is making, they get to keep, and it doesn't get included. If that community spouse doesn't have much income, maybe you're both on Social Security, they can keep a portion of the ill spouse's income, so that what they end up keeping is $3260. And if there are reasons that they need more than that, we can go to court and get that amount raised. But that minimum monthly maintenance needs allowance allows you to keep more of the ill spouse's income if you need it to keep yourselves independent and keep you at home. So those are some key concepts that you need to understand with spousal protection. So it used to be I would have people, and I still have people, come to me and say, do I need to divorce my spouse so that they can qualify for Medi-Cal? No, don't do that. That is not a reason to get divorced. There are many other reasons people want to get divorced, but that's not one of them. So please keep that in mind. Do see an elder law attorney if you want to get qualified for Medi-Cal, and you can use those spousal protections. Next slide. So benefits planning, where we really, as elder law attorneys, come into play, is we avoid that spend down. We minimize it as much as possible. We protect the assets so that your family can inherit the home, so that your spouse can have a life after you've passed. And we protect you for multiple types of benefits. We maximize those benefits, and we minimize your share of costs. Next slide. So we finished the strategies for long-term financing, long-term care, and now we're going to talk about next steps. Any questions first?
Yes, just one moment. Let me pull this up. question here, it says, is there VA caregiver benefits for a widow?
Yes, there are. Absolutely. If you are a surviving spouse of a veteran, you do have the same right to benefits. You are a claimant once your spouse dies. So the benefit that is due is right about $1,500 a month for unmet medical need. So I'm a VA accredited attorney, and I help clients get qualified for those benefits. But there is a benefit there. So that's a very good question.
Perfect. Thank you so much.
Mm-hmm.
Okay.
Any other question? All right. I think, Amy, now would be a good time for me to talk about the Prop 19.
19 question. Do you want to hear the question again? It was, please
Yes.
explain the changes that will occur from Prop 19 regarding a child inheriting property from a parent.
Okay. So one of the things that was not very well publicized in this proposition, and I will tell you, I was just on another webinar yesterday with the County Recorder of Santa Clara, along with the head of the Board of Equalization. And the head of the Board of Equalization had a lot to say about this parent-child exclusion. When I saw this coming through, when I saw it on the ballot, I was very dismayed. The issue here is that the California Realtors Association, they created this in 1 week, this ballot measure. They had the governor sign off on it to be able to get it onto the ballot. And they didn't really tell us everything that this new law was going to do. And this is a constitutional amendment. I guarantee you they are looking at trying to get it repealed because it was so poorly written. What it was meant to do, and what you may have seen on the advertisements, is they used Lloyd Bridges and his two sons, Bo, and I forget the other Bridges son's name, but they used them as an example of these wealthy people that are using the parent-child exclusion to be able to pass on wealth to the next generation. And Lloyd Bridges lived on the beach in Malibu. He has this big palatial estate that's worth millions of dollars. His two sons inherited it. They kept it as a rental property, and they charged $16,000 a month for rent. That's what they publicized. What really, and they said that the benefit why we want to do this has more to do with people that are suffering loss of their residence from wildfires. In San Diego, we have always had the parent-child exclusion, and we have always had this other Prop 58 benefit, which allows you, if you're 55 years or older, to transfer your low basis property tax in a property to another property. You can move to another one that is of the same value or less, and you can take that low basis with you. That low basis property tax is what we're talking about when we talk about the parent-child exclusion. And it was I started writing blog articles about this because it's one of the last best ways that middle income and lower income people who have, your retirement account is your home in a lot of cases. And you want to be able to transfer that wealth to the next generation. So getting qualified for Medi-Cal, your home, your primary residence being an exempt asset, that's all great, right? So when you die, you want to be able to pass that on to your children, and you want them to be able to keep, because of Prop 13 and Prop 60 and 90 that came after, this parent-child transfer. So you can either wait until after you die, and you can transfer it to your children by way of will or a trust, and they get to keep that low basis. So California Realtors said, we want inventory. So we want to change these rules. So we'll have a lot of children be put in the situation of not being able to pay that property tax, that the numbers don't work anymore to keep that as a rental property. So they'll have to sell it. Well, they put one little thing in there that said, but if you use it as your primary residence, then you can keep and transfer that low basis. Well, there are a lot of people that have their primary residence and then they moved and they kept that as a rental property, and they're going to be transferring a rental property and their primary residence to their children. They're no longer allowing you to do that unless you're using it as a primary residence. So you have 1 year to move in after the person dies or after the transfer occurs. And you can keep that low property tax basis. The call that we had yesterday was some clarifying interpretation that's come from the Board of Equalization that says that that is the case. And not only can you keep it as your one of the siblings. So let's say you have 3 children, you don't all want to live in the house, right? You don't have to. Only one of those siblings has to keep it as their primary residence, with the caveat that you would then have to maintain that ownership. If you want to transfer it to another child, guess what? You can do that. And this is from one sibling to another under the new rules. You can do that. One child can move out and another one can move in. But the moment you rent that property out, you've blown it up and you have to pay the higher, it gets reassessed and you have to pay the higher property tax. Did that answer their question?
I hope so.
The other part of that you should also understand is they are looking for more interpretation to come from legislature, because that's not one of the only things that's wrong with it. It also messes up the family farm parent-child exclusion. So be looking at it, and hopefully I was trying to get the word out. Don't vote for this. It's the worst thing. But a lot of people think they may even repeal it because they really didn't, they put too many concepts into one thing and people didn't know what they were voting for. So stay tuned for that.
Great. Thank you. That's
anything else to do with that? Okay.
No,
it's pretty deep subject.
Yeah, we need to keep moving here. So I'll
yes. Okay,
go on.
So additional resources and next steps. Let's get moving on to that. So as we said, gather those important documents that you've got. Maybe you have that plan that you did in the 1990s, brush it off, even early 2000s, brush it off, get it in front of an elder law attorney to take a look at. Go ahead and ask for those beneficiary designations on all of your accounts. Make sure you know who's named there, because we had 2008 happen when all of that consolidation happened. Those banks didn't have those beneficiary designation forms on file when they got bought by somebody else. So make sure you have a copy of it and that you keep it with your estate plan. You want to know, what income you have. What income goes away when one spouse dies? Some people have pensions that are not going to be there for the surviving spouse. You need to understand that. You need to understand what you've got to pay for long-term care, and is it going to last your lifetime? Keep copies of legal documents all in one place. Tell your trusted family member where they're located. When I do a plan, I put everything onto a thumb drive. You can duplicate that and give it to your named designated people in your plan so that they have it. Discuss the contents of that advanced healthcare directive if you're comfortable. And if you're not comfortable, you can do what Amy's father-in-law does and keep it in a binder and let people know where that is. Find out the specific institutions, what they need to have on file, because you don't want to wait until you're in a crisis to have your agent under power of attorney go to the bank and find that it's going to take them 2 weeks for the legal department to approve that power of attorney so that your loved one can pay your bills. Next slide. How do you find a good elder law attorney? I'm biased. I'm in the National Academy of Elder Law Attorneys. You should take a look there. It's a national association. So if you've got loved ones that live in another state, make sure that you take a look at their list and seek counsel from that licensed attorney. There are plenty of people out there that say they can get you a Medi-Cal benefit or they can get you a VA benefit. If they are not a licensed attorney, I would tell you not to use them because it really can mess things up. They don't understand the law behind it. They might get you the benefit, but they might also disqualify you from other things. So make sure that you use a good attorney. And then there's also special considerations when relocating a person with dementia, especially if you have to get a guardianship. We're actually in that process with my mother-in-law. So make sure that you take a look at those things if you're going to change states. And then also Medicaid eligibility is state by state. You've got the best of everything here in California. So make sure you know what you're doing if you move to another state. We thought that Ohio was going to be the cheaper place where my mother-in-law lived. Her rates went up to $13,500 a month for the level of care that she was at, and she was not in skilled nursing. And we're paying half that here in California for very good care in La Jolla. So, really do your homework. Advanced healthcare directive, you can get that online, but remember that you want to make sure you also have a HIPAA as part of that. The statutory form, California form, does not include that. The POLST order, you can talk to your doctor about that, or your nurse practitioner. They know what that form is. Get that in place, especially if you have a diagnosis now, because it will be something that will be important as time goes on. And then compassionate choices, dementia provisions for advanced healthcare directives. They've got some good tools there on their website. Next slide. Legal services. I've already told you about National Academy. The National Elder Law Foundation, or NELF.org, there is a certification test that we take to be able to put some initials behind our name. We have to have a certain number of cases. We have to pass another test, kind of like a little mini bar exam. That's always a good thing to look for. The state bar can give you some resources, and also the San Diego County Bar has a referral service. And CANR, if you've got issues, the California Advocates for Nursing Home Reform, if you've got issues in a nursing home, they do have attorneys that specialize just in that, and they share fees with CANR and help support them. So they really know what they're doing, and I get education from CANR every year as well, so that's a good place to look. Regulatory agencies, the Department of Social Services, Home Care Services Bureau, they also will help you if you're looking for a care home. They will help you to know whether or not there have been any infractions, that type of stuff. You can take a look at that. Department of Social Community Care Licensing Division, that will tell you, again, more about whether they're licensed. And you can find out about the skilled nursing and what kind of grades they get through the California Department of Public Health. And then the senior care programs, continuing retirement communities are listed and regulated under the Department of Social Services Senior Care Program. Take a look at that. Medicare, Medicare.gov, everybody who's turned 65 is probably already familiar with that website. Social Security Administration, the Compassionate Allowances, Medi-Cal. I just had a client the other day go to the Medi-Cal website to get mom enrolled, and she thought she got a denial. So it takes a little while to get through that process, and I will tell you, you will get denied before you get approved. So for various things. A better way about that is to get an evaluation and find out what you need to do to get qualified before you go make that application, and you'll have less pulling your hair out and that type of thing. VA Caregiver Support Program is there. Those are all great resources. So that's the end of my presentation, and I service pretty much North County, East County, and downtown. I have a conference space that is COVID friendly, I should say, in Sorrento Valley. But like everybody else, I am working right from here most days, and we'd love to help you. I have a paralegal who's been doing Medi-Cal and VA applications for 19 years now. She's been working for me for the last 4 years, and we enjoy, that's what we love to do, is help you get prepared for the future. So if you've got any questions, give me a call. And then also, because of Alzheimer's, your association with the Alzheimer's Association of San Diego, I do give a free consultation along with that. So give me a call. Any other questions? So the resources, do you want to talk about this, Amy?
Sure. I'll just give a few wrap-up comments here, and then we do actually have a couple more questions that have come in. If you're able to stay just a few minutes longer.
Absolutely.
You know, back in the old days, this would have been, you know, hanging out in our education room for a few minutes after the class. So, but we'll wrap up here on time. So for anyone who's not familiar with us, Alzheimer's San Diego is a local nonprofit organization. We're headquartered in Kearney Mesa, but we serve people everywhere, of course. Right now, all of our services as well are completely virtual. If you need anything, the best place to start is just reaching out to talk to one of our dementia experts. Rebecca is one of an incredible team of social workers that we have. Our clinical services team, Monday through Friday, 8:30 to 5, there to just take questions, to connect you to a resource, to answer disease or caregiving questions, or just be a supportive ear, right? If that's all that you need. We run, in addition to our online education program, which you obviously have found out about, we offer a variety of free virtual support groups. We have social activities and outings for COVID-friendly outings for people living with dementia and their care partners. We have our virtual Alz Companions respite program. This is a COVID era adaptation of our very popular in-person Alz Companions respite program, wherein we pair a family with a live companion. It's a real person who logs in and does a virtual visit with a person who's living with dementia for social connection, activity, stimulation, and to give those care partners a break. We do offer counseling sessions. A licensed clinical social worker can offer one-on-one counseling to family caregivers, or to caregivers generally, I should say. And finally, our Vitals program, our Volunteers in Touch. This is a telephone reassurance program for people with dementia who live alone. So that's just sort of scratching the surface of the amount of support that is available through the organization, and all of our programs and supports are, of course, free. So you can get information about that through our website. You can call us, email us, you can even live chat us. It is a real person who monitors our live chat on our website, or Rebecca has sent out the social work follow-up request form. If you fill that out, she sent it out in the chat. So if you click that link, you will be taken to a form. It's a secure form. Tell us the best way to reach you, and a member of our clinical services team will reach out to answer your questions. A few upcoming caregiver skill building classes that are coming up. Myself and my colleagues in the education program will be teaching these programs on coping with personality and behavior changes, communication skills, and managing resistance. As always, held via Zoom webinar and free, and open to anyone. All that information is up on the website. Before we wrap up, I'll just let you know when the webinar closes, you'll get a link to a short online survey. It's anonymous. It just takes a moment, and we would love your feedback on the program. I have seen some inquiries, and just to confirm, yes, all of the slides that Yvonne was speaking from today will be emailed out to all of you today, and a recording of this program should be available in our webinar library in just a few days. So with that.
Okay.
So we had 2 questions come in here in the chat while you were presenting a little bit more information, Yvonne. In regards to the Prop 19, I believe this is a piggyback to that. There was a question, can grandchildren live in the house?
Yes, so I think more pointedly, what the question may be referring to is a grandparent-grandchild exclusion. So that instead of being parent to child inheriting the house, it goes from grandparent to grandchild. That is still in the law, but it has the same restrictions, meaning that the only way a grandparent can give that portion of the house or the whole house to that grandchild is if their child, who they have their relationship through that grandparent, is predeceased. So that child must be dead for the grandchild to be able to inherit that portion of the house and keep that low property tax basis. Again, it's going to still have that, needs to be their primary home, or it needs to be the primary home of one of the other qualified inheritors.
Okay.
Hopefully that answers the question.
Thank you for that information. And lastly, question of individual says, I have a joint savings account. Should I transfer it to my living trust?
I always suggest that if you have a trust in place, that you marshal your assets now and title them in the name of the trust. A joint savings account can be used, and it's okay. It's just if it has a lot of funds in it, and you have more than one child, then that can be a problem, because once you pass, it would actually go to that joint account holder. It would not be part of your estate. So it really is, it depends, a good lawyerly answer, on your situation.
Okay. Thank you very much.
Thank you.
I think that covers it. Thank you so much. It's just always a pleasure to listen and to learn from you, Yvonne. This has been a great program. We really appreciate your expertise. To all of you in attendance, thank you for asking questions and interacting with us. It's nice to know you're out there. I hope that this was helpful. We do welcome your feedback via that survey, or reach out to us anytime if we can be of further support. I will go ahead and end the webinar now and wish you all a good afternoon. Thank you, Rebecca, for being with us here today. And thank you, Mona, for providing support to all of us, technical support. And my thanks again to our guest presenter, Yvonne Amrine with Amrine Law.
Thank you so much, Amy. And thank you to Alzheimer's San Diego for everything that you do. I just speak your praises as many places as I can, because you all are doing a tremendous job. Thank you.
Thank you.